Good afternoon, everyone, and welcome to this afternoon session. We have matter 5, which is protecting mineral resources, infrastructure and facilities. We've got some new faces in the room. So, for the benefit of everyone now present, but who's not present at the full lightning, I'll just run through some of the housekeeping and the procedural matters before we move on to the details of this particular matter. So the Central and Eastern Berkshire Joint Minerals and Waste Plan has been prepared by 4 authorities. Throughout this examination, we just refer to the authorities for ease, and similarly the plan itself has the plan. My name is Rachel Bust. I am Chartered Town Planner, and alongside me is Nick Palmer, who's also a Chartered Town Planner. So we've both been appointed by the Secretary of State for Housing Communities and Local Government under Section 20 of the Planning and Compulsory Purchase Act 2004. So we're holding this examination into the soundness of the plan and to produce a report of our conclusions and recommendations with regards to the soundness. So in case you're not familiar with examination proceedings, please just address us either as inspector or as Palmer as Bust. Can everyone hear me through this microphone again? So just a few housekeeping matters. First of all, I'd like to introduce Stephanie Street, our programme officer for this examination. So you should have already met Stephanie as you arrived. Stephanie works under our direction and has not been involved in the plan preparation process either directly or indirectly, but she's responsible for all the administrative arrangements. So outside of the hearing sessions, any contact you need to make with us is through Stephanie. A reminder about signing in. If anyone's been out of the building, new to the building, needs to sign in at reception, which is the requirement for the building rather than this examination itself. In terms of the layout and seating in this room, anyone wanting just to simply observe, but not participate, will be sitting at the back. And then the usual conventions apply that the person who's sitting at the table will be the person speaking as the participant, and anyone who's just assisting and supporting can sit behind and then swap places as and when necessary. There are 4 authorities in this joint plan, so we have two seats at the table. We're going to keep using microphones. They've been effective so far, and if we carry on doing that, there's no special instructions, so you just press the button on the right-hand side, and the light comes on, and then it switches off again when you finish talking. And I understand we're not to touch any of the other buttons on the microphone. We're not expecting a fire alarm. It's tested on Mondays at 9 AM, so if it does sound, it will be a drill, and the assembly point, as we understand, is outside the front of the town hall in the fountain. The toilets, the nearest toilets to this council chamber, if you can find them already, are to my left outside across the hallway. And we have a camera up on the wall over there, as we are recording sessions, and they will be uploaded after the hearing sessions are finished onto YouTube. So we're not live streaming at this time. Is there anybody else who intends to film or record the proceedings in addition to the So our role as inspectors is to assess whether the plan satisfies the requirements of the 2004 Act, the accompanying relevant regulations, and whether it's sound. So in order to be sound, the National Planning Policy Framework states the plan should be positively prepared, justified, effective and consistent with national policy. So the hearing sessions are therefore designed to assist us in that regard. In submitting the plan, the authorities consider that it is sound, and that's the starting point for the examination. So where anyone is challenging the soundness of the plan, then they need to explain why and what changes would make it sound. We will be taking 1 or 2 notes throughout the session as an aid memoir when we prepare the report, but it's not going to be a transcript of the proceedings. So just a few words on changes. So once the plan has been submitted, there are only 2 ways changes can be made. Firstly, the main modifications, MMs, which are recommended by inspectors, and secondly, the additional modifications, the AMs which are made by the authorities on adoption. So taking the MMs first, for us to recommend MMs, if required, to make the plan sound, the authorities formally invite us to do so. The plan has a policies map, but that's not a statutory development plan document, so consequently we don't have any power to recommend modifications to it directly. However, in the event any modifications to the plan do require consequential amendment to the policy map, then these are going to be published alongside the NMs rather than as part of them. However, we can only recommend main modifications if they are necessary to resolve problems that would otherwise make the plan unsound. So by way of definition, a main modification are changes that would materially alter the plan or its policies, something that's contained within the policy boxes. So in the interest of fairness, any main modifications will be subject to further public consultation, which will take place after the hearing sessions, and may be accompanied by further sustainability work as necessary. Additional modifications are changes which do not materially affect the policies in the plan, made by the councils on adoption and sometimes referred to as minor modifications. So additional modifications do not fall within the scope of the examination as the authorities are accountable for them, as they typically involve factual updates, correction of typographical errors. Now that said, there may be some additional modifications that participants want to talk about, and we may have some further questions on whether some of the additional modifications would be better as main modifications, necessary as main modifications. So the authorities have already proposed a number of changes to the plan in their schedule of proposed modifications document, which is on the website, and that's MD01. And they've referenced the proposed modifications in their hearing position statements. But at this stage, I have to stress that they are only proposed modifications, so they're just an hour on this to assess whether the submitted plan is sound, and we'll discuss the proposed changes as we go along. So we will ask at the end of each discussion of issue whether there are any main modifications proposed and make sure we've all covered the main modifications that are listed. So this hearing session is main matter 5. There are no changes to the programme. It is scheduled to finish no later than 5 p.m. We'll see where we get to. We'll have a mid-afternoon break around about 3:15, 3:30, or a similar convenient point. So I'm going to be leading this session. There is an outline agenda, which is very much an outline agenda, which is the style that we've chosen, so we've got signed to that. So the hearing sessions themselves are a structured discussion, which one of us will be leading, and they're based on the matters, issues and questions which are available on the examination website. We're both going to sit in all sessions. Mr. Farmer was leading this morning on matter 3, and I'll be doing matter 4, and on this one this afternoon. And I will lead on everything else. Mr. Farmer will take 6 now. So in order to test the plan for soundness and legal compliance, we'll need to ask some questions. We have been asking questions throughout the process of the examination so far. Preliminary matters letter to the authorities in April, and then also the matters, issues and questions in August. Now there are a number of matters, issues and questions that are set out in the document, and it may be the case for some matters that from the written representations, the hearing position statements, we now have enough information to assess the soundness of each issue, so there may be little or no discussion on these. So the approach is to invite people to speak at particular times. If at any point you wish to contribute, please indicate your wish to speak, and turn on its end, as usual practice. When speaking during sessions, if you try and be as concise and specific as possible, that would be helpful to everyone. And if you wish to highlight certain parts of your statement or other documents that form part of the examination, then that would also be helpful. And everyone present, if you give document references, page or paragraph numbers. So we would also like to remind participants that you should have provided all of your evidence in your original representation and in the subsequent hearing statements. But this is not an opportunity to submit anything further. Any comments you make during these sessions relate to points made in your representations so far. We have read all materials you've put to us, that's the original representations and the hearing statements, so there's no need to repeat in detail what you've already said to us. So the purpose is for us to clarify and seek further information on outstanding questions that we may still have. So the hearing sessions are a part of the examination process, and therefore the examination as a whole remains open until our report is submitted to the authorities. However, we're not inviting any further representations or evidence after the hearing sessions are closed unless we specifically request it. In terms of site visits, we have seen a number of sites from public land, and as part of our general tour around the area to familiarise ourselves. But we may need to visit some sites again after the hearings, and we'll do this unaccompanied unless we need to go on private land and access needs to be arranged. If we do need to arrange access, we'll arrange these through Stephanie, the Programme Officer. Does anybody have any questions about the procedural part of this? Thank you. Right, could I ask the participants who will be speaking at this session to introduce themselves, please? I'll begin with the authorities on that.
Thank you. I'm Melissa Briggs, Planning Policy Manager at Berkshire Services. I'm Sleep Planning Project Manager at Berkshire Services.
Thank you. And to my left.
I'm Michelle Kidd, I'm an Environment Agency.
And I'm Lauren Giddings, the Biodiversity Officer for the Environment Agency. Just to clarify, which matters are you going to split in between you?
Yeah, Laura will be speaking about the matters related to biodiversity in Monkey Island, and then I'll be speaking about the permitting in Monkey Island.
Right, okay, that's fine, thank you.
Good afternoon, Nick Patterson-Neil from Barton Millwall, representing Commercial Estates Group, with the Syngenta, with the joint promoters of Strategic Development in Bramble Forest.
Thank you very much. Right, turning to my agenda, the first theme I've got on there is the relationship between policies M2 and W2. I'll come to the authorities in a minute. There's a minerals and waste safeguarding area, and my concerns with the combination of minerals and waste all into one area. So that's what that first point is about. So, attention authorities, Mr. Rose, if you'd like to just explain to me the rationale or the reasoning for putting minerals and waste together, that would be really helpful.
Thank you. So there's a requirement in the NPPF to produce a mineral safeguarding area for resources. There's also a requirement to safeguard minerals infrastructure. So the two of those are combined under one mineral safeguarding area, so you've got the resource and infrastructure that feeds into that. Now under the NPPW, it's not as explicit as it is in the NPPF, unfortunately, but it is implicit in the fact that planning authorities need to have regard to existing waste infrastructure when they're making decisions on non-waste development. And so what we've done is combined the need to safeguard waste infrastructure in with the minerals and waste, so mineral resources and minerals infrastructure requirements. So what we have is one, we've only got one layer, but one particular area where we need to take safeguarding into account, and that's useful in terms of information for the authorities as well, because we've got that all literally available as a data set to them. So we refer to it as an area, but it's also an information set which we need to apply to decision. So it's because it's in national policy, it's specifically for minerals, but we're also tying in the need to recognise protection of waste infrastructure as well. It's an approach that's been used elsewhere that we think is a useful tool for users of the development plan to consider safeguarding more widely.
Okay, so it's used elsewhere, which other plans have you referred to in that? Were you moving on?
It's something an approach we use in the Hampshire plan in terms of having both minimum sized safeguarding in that way, applying buffers. Obviously that's a two-tier plan, which you do appreciate, but obviously there's a need to consult neighbourhood authorities if there's a potential order that could impact on the policy. In this area, obviously, because the administrative boundaries are relatively small compared to a county, there's always potentially going to be an impact on a neighbourhood authority on that side of the development.
So has that always been approached throughout the preparation of this plan to keep those two topics together in one area? What would be the harm in keeping them separate? Two individual data layers.
I don't think it'd be harmful to separate it out. I think it's actually, if you read it, it would actually be more user-friendly in some sense of the development plan. I think particularly it's relevant when you've got something which is, for example, agri recycling, which is technically a waste operation but it's receiving a net material, but its product is sort of aggregate. I think that's helpful in a sense where there can be some confusion about where that type of lies as it deals with waste. By trying to incorporate both minerals and waste infrastructure and the safeguarding of those in the same way, it's a more consistent approach. So the approach we took to that was actually it would be more beneficial. We haven't, we're not aware of probably coming up in both in New South Wales, for example in Hampshire, but it's interesting, it wasn't there to be difficult for the users, it's meant to be an improvement and more helpful.
So to summarise, from your perspective, you find that helpful to be combined into one area, and it makes it easier for the users of the plan to understand how things are safeguarded in totality for minerals and waste.
Yes, because it's there to initiate discussion. So for obviously the resource, it is slightly different to the infrastructure, but it's a different type of what that would generate in terms of the land, safeguarding the land use and protecting for the waste, it's for the capacity and the sites that we've got there existing. So it would be, it's the potential sites and existing sites for waste, but for minerals, again, it's the potential and existing sites for mineral use. So yes, it's a slightly different approach because you're protecting the resource, but in terms of identifying the things that we need to initiate discussion on safeguarding the potential impact, our view that was combining them all together would be a more user-friendly approach.
What types of waste use do you include in that? Is that specific criteria or would select those specific types of waste use to be accepted?
We have, because it's such limited capacity within the plan area, we've taken more of a blanket approach in terms of, I know that's where, so we use the Hampshire plan again, that's applied a safeguarding approach to sort of more strategic and more specialist facilities. Within the Berkshire area, there's such limited capacity for waste uses, we've taken a more blanket approach in terms of trying to safeguard the capacity that's already existing, to try and prevent that from being reduced even further.
So coming back to a user's perspective, using the plan and looking policies map. I appreciate it. Because digital, it's electronic, and you can turn layers on and off. So how are you proposing to illustrate minerals and waste safeguarding area?
So that, I'm hoping that will always make it easier for the user to see it in practice, because we can use some of the applied specific symbols to identify those sites that are already existing on the policies map, so you can see the types of facilities that are already there and where they are, and that those would be safeguarded, and anything in the home need to be safeguarded and protected. And then the resources shown as the shots and gravel and sort of sand materials are shown sort of geographically. So actually on the policies map, I'd hope that it's almost more easy to see visually about how to apply a safeguarding area.
Just in terms of the rest of them, anybody else got any comments on that from experience as well? Okay, I'd like to move on to the next topic, which is the geographical extent of the safeguarding area. And I think I'll turn to Pastor Neil to start this topic off, please.
Thank you. This topic in agenda, I think, is strategy to the questions 5, 2, and 4, which I think Mark says, and it's related. Sorry. The concern that we set out in our presentations relates to the extent shown in the proposals map, trackers of the mineral safeguarding area and certainly the corresponding area of search. For my clients, land at Jebs Hill, which is a very rural private forest district, close to the boundary land which is identified in the species draft regulation 19, which private forest, which is shortly seated to Secretary of State by private forest. That is a site which is currently occupied by Jebs Hill crop research around 850 people. The site is a significant existing operation. The proposal in draft private forest plan relates to some 2,000 homes and new sites associated with the existing ongoing asset. As such, it's a key part of private forest spatial strategy going forward, both in terms of housing delivery. So, looking at the question, that's the context behind my particular interest and approach here. In terms of the geographical extent of concerns we have is in relation to the proposals. That's born out of the concern about the imbalance in balancing these two pieces of in this case strategic and social growth. Now, the draft policy, of course, I fully accept acknowledges that it doesn't include non-minerals occur. But equally, as identified in my hearing statement, the safeguarding study undertaken by the authority indicates the approach to safeguarding needs to be realistic. And in this case, in my view, this has to have regard to policies and other wider local plans within the authority's area. In my view, it's very much the case that the minerals plans, in the case we should call it here, that we're considering today, needs to be aligned with some plans in this particular area. And in this particular case, it's supported in our presentations, notwithstanding the fact that it's an issue of strategic development, which is of overriding importance and interest, and perhaps helpfully turning to judicial modifications document. One of the modifications is sought to clarify the other questions, which is judicial modification 29, 24 document, which is change paragraphs which, in response to your questions, seeks to clarify sites of demonstrable overload importance, as the phrase defines as those being required to ensure the delivery of other plans. Sites Here we have a situation where the safeguarding area identifies land which is clearly proposed or something which is demonstrable overriding importance. But also, notwithstanding that, our clients have presented information to authorities and examination of regulating representation through the preparation of mineral resource assessment. Acknowledgement that that's an important part of clarifying whether or not any mineral resource deposits which do exist are workable and viable. I won't go through that very depthly before we consider representations, but in summary, concerns with regard to the volume, quality, and regards to others, as infrastructure, housing, other development of roads, given the actual juxtaposition where those deposits lie, is such that those deposits are unlikely to be viable and workable. Our clients have engaged with a number of those operators to see their view on that and set out. So the concern here is that we put forward evidence for Berkshire Council's response in their hearing statement on the second page. Statement, the authority statement to this session references the solutions that we made and sets out page 2 their response. And essentially, it's one that indicates that this is an ongoing process that should be dealt with at the DM stage. Now, I said that there's an instance in the policy to go through those process, but here, where there's evidence before this plan that clearly indicates both the primacy of development of overriding importance and the native like liability such that in order to ensure the deliverability and effectiveness of that proposed map as an adjunct to policy number 2 should actually reflect aligning itself with the Brown Forest local plan as it's really brought forward to effectively exclude that land from that designation.
Thank you for that. So in summary, you're seeking to sort of step into the development management process and bring that into the policy making, the plan making process by trying to have that area modified to exclude site that's been noted.
Well, I think it's a site of such importance to the particular question because it scales significance to that social strategy. So 2,000 square metres of forest versus 2,000 houses is a very significant proportion. And given that significance and the evidence already available, such that it doesn't need to be met to a subsequent stage. I mean, acknowledging obviously that as architecture policy itself to go through this process later, but I think that the evidence of importance now is to give clear policy direction in this plan by acknowledging the full version of the local plan process with Brown Forest, which is clearly expressed the position of Brown Forest, who obviously consulted upon that about to submit the plans in the Secretary of State.
Thank you. I think my concern here is that the NPPF doesn't refer to the need for an economically viable resource to be used to define a safeguarding area. So if there is resource in that area, that is the starting point, and the mineral resource assessment is therefore the next step to assess it. So it sounds to me, Mr. Neil, if you've done that work already, then that's how we support the plan application of that strategic site.
Clearly, that information would be utilised in that context, undoubtedly so. My view is that when one has the benefits of that information, it's about reflecting a clear understanding of that resource is of such a modest volume and constrained by the specifics of that it's unlikely to be a workable resource going forward. And therefore, this plan should be focusing on its safeguarding area for development which, sort of minerals development which has a prospect.
I'm just going to turn back to the authorities for any particular comment on Mr. Fessen's position.
No, thank you. I mean, our position is that you've kind of highlighted that we don't think that this is the forum for the discussion of the content of the mineral resource assessment, and we're aware that those discussions are still ongoing between Bracknell Forest, directly as in the Mineral Planning Authority, and regarding the site which is still proposed at this stage for the Bracknell Forest plan. I do feel that actually, in some ways, it's an indication that the policy is already working. It's identified the safeguarding material there, and mineral resource assessment is being connected, and the process is going through as it should do. But equally, we have added in a modification to explain that we do appreciate that this is part of the wider minerals plan and the local plan to work together. And there may be some instances where a need for such development may lead to conclude that the price action cannot take place, but our policy is trying to direct that in all opportunities, potential for price action should be maximised, and really that should be the starting point, that the price action can take place, and rather than trying to prove that it can't.
Just go back to Mr. Patterson, please. Just thinking about the mineral resource on that strategic site. Would you be looking to use any of that material on the site for that development in due course, or are you seeking to just develop that site without prior extraction?
In essence, we don't believe that there is a likely prospect of that being capably utilised, both in terms of volume, but also the quality of material as well, which will be identified through support health assessment on the boundary of our land question. So we think that that's unlikely to be the case in the housing when the site is developed. I think the other issue is, of course, it's an operation size the same from the size of the moment. So there's challenges with undertaking such an exercise. So, but I think it's borne out of our consideration of the policy as an emerging forest is longer development, but also the evidence, the quality, the extent of those. There's a couple of maps that are tail end of our recognizing routes, which is quite useful to just visually show the position of the last page, second appendix to the recognizing state. Just people know really to look at that session, but I think that's quite useful to show this fragmented nature of this boundaries are such that it's very likely that
Something else on the second topic. I'm going to move on to the third topic, which is about the safeguarding area and the consultation area, so the use of MSAs and MCAs. Typically, it's used in two-tier areas. I appreciate that not two-tier areas, but you are authorities working together. So, presenting the script, please. How this use of MCAs and MSAs work in practice? Could you see that working? Or no? Thank you.
Oh, yes. I appreciate it is something that is primarily used in two-tier areas, as referenced by footnote 17 of DPF. However, because of the nature of the central eastern Berkshire number of small mineral planning or local planning authorities within a small area, and there's quite links with other local planning authorities such as Slough and West Berkshire and cross-boundary. There's a number of issues that mean that mineral consultation area would work particularly well in this plan area, mostly within the Central Eastern Berkshire Authority area themselves, when they have local plans or planning applications. And mineral consultation area encompasses that wider minerals plan area, I should say, so that any local plan or application can be consulted on the neighbouring authority. But like I say, with Slough and West Berkshire, with other sort of ongoing movements and relationships, it has that continuation of a working relationship, but also where mineral extents across the boundary, it does allow for that consultation to take place. And so it might be joint proposals which are looking at the same source. It might be that something being proposed, for example, in Reading or just working and it could be a joint up discussion on it. So it was meant to be enabling in terms of enabling discussions and consultation and proposals in each of the authority areas that could impact on their neighbour. So it was to encourage engagement.
Thank you. Yes, I understand where you're coming from. In terms of illustrating it in your minerals and waste plan, though, how is it expected to affect the ones outside of the actual plan area? So within, I understand within your constituent authorities, but if you're talking about neighbours outside your plan area, how does that get illustrated so people know what that means in practice?
Yes, I was just trying to find the exact paragraph number referring to, but we explicitly stated some buffers to be applied, so mineral and waste sites. I think it's 250 metres, so extending within those sites to show that the encroachment isn't an issue. And to visibly show it as a GIS consultation area, so we can send it to neighbouring authorities so that they've got that tool to be able to cross-check an application or other site boundary. If it falls within that MCA, then to consult the Berkshire Authority areas.
That's helpful. So what you're essentially saying is there's something that's internal, so it's an administrative process. Where I'm trying to get to is how is somebody who's reading the plan going to understand about mineral consultation areas when that's something that you normally consult neighbours with as a matter of course on planning applications, and I do understand that's the mechanism that authorities talk to each other, but from any user of the plan, they would understand what's the difference between the consultation area and the safeguarding area. And that's where I'm trying to get to. Particularly how are you going to illustrate that on your policies plan?
No, I can see where you're coming from in the fact that users of it's more of an internal mechanism. And I can see that where you're suggesting that actually with it, by talking about something that the user of the plan may not necessarily use unless it was a neighbouring mineral planning authority or planning authority would potentially pick up. It was meant there to be helpful and additional information, but I can see from what you're suggesting it may be more confusing to people in terms of the consultation area. It's getting that balance right in terms of for others to be able to pick up and we'd like to consult them as a mechanism, and whether we want to talk about it or whether we need to address more about it, explain it more that it's an internal tool within the sporting sector rather than elaborate further. So people that it would refer to, such as neighbouring authorities internally, can explain that we would have a consultation purposes for it rather than talk about it broadly. So I would be happy for us to review the wording on the consultation area to make it clear about the purposes for it and a bit more detail tool, but reference it so people know that it's there, so we can explain that it's an implementation tool. Would that be helpful?
Yes, I think that would certainly be helpful. If you could just go and reflect on that. MCAs are very useful, but in including something, it often raises questions to users of plans. And it might not be that user that needs to know about the consultation area, and it's more, you all know what's going on. But somebody looking at the plan for other reasons would think, well, what's a consultation area? Does that mean me? Are you going to consult a resident on things? And that's where it's frustrating to statements of community involvement and that kind of territory. So just by being helpful, we can actually be a little bit too helpful and lead to other questions. So if you could go and reflect on your mineral consultation area and how you actually want to talk about that in the plan, I think that would go some way to addressing the potential ambiguity there that I've got on which.
Thank you, I think that's what we have for you.
Anybody else has any points to move on to prior extraction threshold of 3 hectares, please. And I'm going to turn to the authorities first. In terms of, if you could just summarise how you would derive the 3 hectare threshold, please.
Sorry, this was based on existing sort of practice elsewhere in terms of looking at the viable thresholds. We know that in Hampshire they apply a 3 hectare threshold. I mean, elsewhere in other state governments, I think Essex is 5 hectares. In terms of looking at what is viable, those have been tested in their local plans as being reasonable. As a neighbouring authority with similar resources, the approach was taken for Berkshire that about 3 hectares would be viable as well. Obviously, consulted on that, and there's been an industry to suggest that is the correct level. So we've gone ahead with some confidence that we feel this is a reasonable threshold for viable.
Okay, so you've been influenced by what neighbours have done, others have done. And obviously their evidence base of their plans would justify the reason for that threshold. Often with prior extraction, authorities tend to look to what size their applications are, they look through planning application histories in terms of the site sizes, and then to derive a threshold that they settle on. So it can vary between authorities. You mentioned Essex is 5 hectares and Hampshire is 3 hectares. So in terms of effectiveness of the policy, I'm not averse to thresholds per se. But I'm just thinking, have you done any work in terms of how many developments would be caught by the threshold, how many would come under it, and how many would come over it, non-mineral developments? I'm thinking not so large strategic sites because they would be above 3 hectares anyway.
No, we haven't tested that in terms of what that would mean. There wasn't a great amount of evidence of existing applications of safeguarding to draw upon in the Berkshire area, unfortunately, for examples. But we haven't applied that testing to see what that would mean in terms of what developments would not be applied, what that would capture. But what we could, something we could do based on the plan where that is quite required, but that isn't something we have done today.
That causes me a little bit of concern in terms of effectiveness. It does feel a little bit like it's a 3 hectare, it's sitting there, and that's being chosen for the reasons that you stated. we need to understand is how much of influence would that have on development proposals? So is it a reasonable threshold? And what underpins that? So is that something you'd be able to go away and just have a look through past applications, non-renewable applications to see when fire extraction would be triggered?
I think, yes, we'd be able to gather information. I think I would hope that we could achieve that by the 12th of October, but it would require quite a lot of information from each of the authorities to help us inform that. But we could look back to a reasonable period of time, 5 years or 10 years, or if you have a preference for a period of time.
Yes, I think probably some early work on that could be by the 12th, which is our reserve session. As much as you can achieve in that time, obviously would be great. But if you could just scope it out, it's probably, if you can go beyond that, then that's great. But if you could just sort of get into a handle on how much of that work might take. It may be that, depending on how the authorities keep their planning application data, it may be relatively quick to search through some sliders. Probably about 5 years would be sufficient just to have a look back. And I think that would give you the evidence that would make that three hectares more effective.
No, thank you. We want it to be effective, whatever that takes to do that, we'll be happy to do that.
Just going to turn to plan modification 9 that you put forward. Policy M2, which is in the bin. Proposing to insert the word permanently within that modification. You've got the page. Now, the justification on there is to provide clarity of how policy M2 may promote temporary development. Now, the other way of reading this is that temporary sterilisation would be acceptable. Is that really what you're thinking by inserting the word permanently?
I think this has come from the point that some toilets have only got temporary permissions. And so therefore, would they be sterilising if it was only a temporary position? And so this was trying to clarify that we'd be concerned if it was going to be leading to permanent sterilisation. That some temporary developments may come and go and therefore haven't sterilised the material. So this is trying to sort of clarify that it will consent back to permanent sterilisation. That's what that was aimed at trying to help clarify. Sorry.
Thank you, that's great. Does anybody else have any comments to those? So moving on to buffers. Just a quick question on the The question is how are you going to illustrate the buffers when your land boundary ends at a geographical point? And the buffers that you're talking about were going outside of your plan area. Are you intending to illustrate those on the policy map?
We can't obviously show stuff over the plan boundary, so we'll be going up to the plan boundary. So the buffers obviously will be more of a delta and going over the plan boundary, but yes, the buffers will only be the boundary of the plan area.
Thank you. Just need to clarify that point. Right, that takes us to policy M7 and the monthly annual, unless anyone wants to do anything else.
I don't know whether you're going to come back to the additional modifications. A lot of points about those. I think you suggested you might come back to that.
Thank you, yes, I intend to come back at the end once we've dealt with. Can I turn to the environment to start with, or Monkey Island Walk, the application and policy M7? See if you just take that, or you can share.
We might share a bit of this one. Okay, so for this, we've looked at this site allocation, and we have some issues with the potential impacts on biodiversity site, and we've had discussions with the local authority about how we can approach that. But we've looked at the options that they have for mitigation, and we would need to see some off-site mitigation for the biodiversity impacts, potential impacts of developing that site. So yes, that would mean some off-site mitigation that would have to be connected to the river cut. So we would need to know that would be possible. And with it being off-site, one of our concerns, well, it might not be under the land ownership of the developer, and how would that be possible? Yeah, we've about that in our statement. About the restoration upstream, compensate for the potential adverse impacts downstream. And there are one or two other development considerations that we discussed with the council as well. That was one of the main concerns. And also, they mentioned reinstating the use of the river cut when we don't have a record of that being used in the past. So we're a bit concerned about the use of that wording, the development considerations, because it might be a bit misleading.
Should we just pause at that point and turn back to the authorities and get that using Ms. Briggs, Champion?
Thank you. We did have a meeting with environmentally to discuss the biodiversity issues of this site. And from that meeting, we had a go at drafting some additional development considerations based on that discussion which we submitted. Obviously, since then, we've now received the Environment Agency's response to your most issues, which obviously sets out nice and clearly exactly what they're seeking to achieve. And we'd be happy to redraft those declarations along the wording that's been provided by the environmental. So I think we were attempting our own interpretation of the discussion that we'd had, hoping that would meet their requirements. But now we've seen the wording that how they've set it out, we'd be happy to use that wording for those requirements. It is difficult in a plan to be able to demonstrate that off-site matters can be addressed, and obviously we also haven't got the operator here, but we do know they've got, that's a large site with water ownership in that area. Yes, the reference to the statement, there is a conveyor infrastructure is still existing on the site. We knew there was a link with this site to the extraction of the Dorney Lakes. And at the time I wondered whether that would come up from barge. That was actually conveyed, I think there were about 2 miles of conveyors came up from the Dorney Lakes into the on-camera processing plant. So the existing bit of conveyor that comes up through the site up to the cut, obviously very rigid, but the infrastructure is there. The conveyor belt will need to be replaced, but the infrastructure taking the conveyor through the site up to the cut is there. And on the other side of the river is some sort of bridge or motor that was there, which is previously. It was all just conveyor. I presume that was to do with changing levels and getting material into Monkey Island. But yes, there isn't any evidence to suggest that the cut has been used for barge previously. It was initially cut for flood alleviation purposes. It's got public navigation rights, and it's just used for commuting because it is quite overgrown, so it's been highlighted. But I do understand Maidenhead waterways are looking at opening up waterways in the Highway, and I think this is on the list of future proposals as a future scheme, but it hasn't got funding, and I do recognise that the issues of needing to potentially dredge and deal with environmental issues. But I think all that ties up with the vision for potentially this coming forward as a wharf available for barges, and we're obviously keen on it because it's one opportunity to try and get some vehicles off the road.
Thank you for that. So would you be amenable to working with the authorities and creating something that's
Yes.
comfortable with that? And then that can come back to us for consideration on 12th October at the session.
Yes, so I just wanted to make another comment then that about Maidenhead waterways, that would be slightly different use than it would be for the minerals and the sand barges would be larger craft, I'd imagine, than just the leisure use. And that the Maidenhead waterways, just I don't think it's, I'm not entirely sure, but I understand it's just aspirational to use that section. I don't think there's been planning permission for that yet. But, so, yes, just for awareness that it would be a different use. And perhaps we're concerned about the dredging and the alteration to that. The environment, the biodiversity in that section of the river and the water environment and the impact that might have. So that's where our concerns are. That needs to be addressed. Perhaps through the upstream, that have to be connected to the water, the mitigation, the compensation, and the possibility of that. And that's what our concern was about the viability of this site allocation, and that's achievable. Yeah.
Thank you. Just asking, in terms of the biodiversity interest in that area, has anyone done any assessments at this stage of what biodiversity interest within that cut area?
No, from my understanding, when we had the meeting with the authorities, they haven't done any surveys about what is actually there. And what we do know is that it is classed as a local wildlife site called the Greenway Corridor, and
So from your perspective, the current state of that area in biodiversity terms, would compensation elsewhere be an acceptable alternative?
Yes, we would require that compensation to be as near to the site that they're working on as possible. The reason for that is that's just generally good practice, and if you're going to be reducing the biodiversity in a particular site, then you're going to want to enhance the biodiversity in a site that's as close to where you're working as possible, and so the same wildlife get that benefit, and to an extent the community as well. It's the general principle in the biodiversity net gain metric as well, that if you need to do off-site compensation, then it should be as close to the site that you're working on. And we'd also want it to be in the area of the local wildlife site, and that doesn't extend too far upstream on the cut from where the proposal is. It does extend up the main ditch, but that's a different type of result. Okay, I think that clears that one up. If you're going to get together at some point between now and the 12th of October and have a conversation and decide what we can agree on, that would be really helpful to us. So that takes me to the end of those themes that I've got on the list. So just turning back to the list of scheduled modifications.
Excuse me, sorry, I just point about permits as well, that I meant to raise.
Sorry, you did mention that's at the beginning.
That's the environmental permit for the main river that they'll need. That's just separate from planning, they're different consents. So you've got the flood risk activity permit, which looks at it's looking at the main river and whether or not the dredging is quite similar, that the flood risk biodiversity issues, but it's a different planning, separate. But the other consent is associated with the use of River Thames and our navigation and waterways team. So I've thought about this, and they didn't have any record of that. The cut being used for the barges, we were not aware of any in the past. And they can't say at this stage whether they would have an objection principle because they don't have enough detail based on the information they've been given, and how often the barges will then go onto the Thames, where they'll travel on the Thames, the use of the locks on the Thames, so it's all about the navigation. That's the accommodations licence. I've got a bit more detail about that in the statement that I've written. So they can see the detail of that, and my concern was that might affect viability of this site, but I'm aware that they are separate consents to planning, but I thought I would make you aware of that and raise that point, because I didn't want to get to the point where they're looking at this as a planning application and then these consents became an issue at that stage.
Any response on sort of permitting and cross-consenting regimes, and how you represent that sort of information in the plan, just information?
Yes, we following our discussion for the proposed LN14, when we initially drafted and redrafted the further consideration following our meeting, we did add in that an environmental permit would be required. I believe that's when I can check the plan we talk about the licenses and requirements being. I think that might be under the policy, which was possible. I can double check, but yes, those are outside of our control, but we're very happy to flag up those sort of requirements. But in terms of those that will have to be dealt with part of that application.
Okay, so
Turning to the schedule of proposed modifications and just have a look through the additional modifications. The one that I'm homing on is AM 31, which is obviously related to policy M2, which I appreciate is a monitoring indicator. We do have a session on monitoring, but I'll just pick this one up now as we're in this particular policy. You're proposing a new monitoring indicator there in the second half of that box, the amount of sand and gravel including soft sand, so no increase over 5 years. Could you just explain to me where this one's come from and how is that going to help the effectiveness of policy M2 monitoring?
I'm questioning this for myself. I'm not going to have to come back and work out what the background is from with the other list. I can see why we changed the one above in terms of safeguarding resource sterilised. But the one before, I'm going to have to double check it. Because the reason why we posted it out, I think that's okay.
That's fine. Thank you. If you just make a note to find out a little bit more about that one. I'll also decide whether that's necessary as an additional modification, whether that should be a major modification. As we take into consideration of that. Thank you. Has anybody else got any comments on any of the main modifications or additional modifications under this main matter 5? Neil, please.
Thank you. It was in relation to AM 27. This goes back to like the question of that's the point about what's included in an MRA. The council helpfully, the authorities helpfully set out those additional application references made to the Rural Products Association and Society POS document and indicated consideration which should be given to guidance such as when one turns that guidance, it does then refer to the BGS practice guidance which we deal with. And I think the balance is struck between awarding a due prescription and also giving due application. It's the expectation of what should go into it. So also I welcome the additional modification of the target. I just want to raise the question about whether or not that gives sufficient clarification. It doesn't occur to any guidance that can be found in PPG, for example. The EGS will be those constraints. And secondly, which is raising the question to the point that you just referenced in the previous modification we talked about, is whether giving such additional clarity in this part of the security text actually represents a main modification rather than should be consulted of. If now, understandably, in response to your question, those additional clarifications to what guidance should be considered, I think that's probably a slightly more significant change to the text, which merits at least public consultation.
Thank you for that. Any response from the authorities on that?
No, I think there's quite a lot of helpful detail in here for policy guidance, and it goes into it's moved on from the earlier version in terms of when a MRA might be required, and quite useful guidance about the steer and what needs to be contained in that decision making in early discussions before that guidance was prepared, there were some informal discussion here about whether an SPD would be required, but actually a lot of what is in a number of SPDs is now in the MBA plus guidance, so I think it's a useful tool. I do want to limit it to just that guidance in the modifications, which is why it's guidance such as, in case during the course of the life of the plan, further guidance comes out, but personally I think it's extremely useful information. I don't personally feel it's an additional piece of clarification that's meant to be a helpful guide for people using the plan, rather than a main change in policy or approach.
Yes, I think mineral resource assessments are a very interesting area, and obviously they can turn into SPD, so I think that's probably a good thing to think about. I think whether or not something needs to be in a policy or supporting text is something about the balance between clarity and not making the policies so large that they become unwieldy, and certainly for development management colleagues who are determining applications, you've got a policy that stretches over several pages. And I think any guidance on mineral resource assessments, whether that was in the original guidance or supplemented by this more recent PRS publication, I think is really needed to just be signposted for people to go and look at, not necessarily in a plan. I think that's something we're going to reflect on, isn't it? So we'll reflect on that particular point as to whether that's an AM or an NM or an alternative way of trying to get the message that needs to be in the plan is the guidance to users of the plan, so they can be clear as to what they need to submit, and there's no debate about the quality of the mineral resource assessment in terms of not assess a certain aspect of it, but also giving clarity for decision makers too. So I think we'll take that one away and we'll reflect on that one. Right, does anybody else have any questions on anything else relating to Matter 5? Anything else on that? Okay, well that's all from our side. That's all we need to seek clarification. So thank you very much for everyone's participation today. That's been really useful and helpful to us. It's just been up to 3:15, so we will adjourn hearings now. That's the end of Matter 5, and we shall resume tomorrow morning at 10 AM for the next session, which will be led by Mr. Bonner. Thank you very much, everyone. Goodbye.